Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 187 of the NCDWI Guy podcast. On today's episode, we continue our conversation that we began last episode about how to get discovery on your DWI cases in district court. Now, this episode is going to be helpful for anybody that is trying to effectuate a policy change, whether it comes to criminal procedure, certain types of cases that are being heard in your local jurisdiction, the deals that are getting offered on certain charges. This is somewhat of a policy change episode that will be applicable beyond just the discovery realm. So if you're trying to effectuate some other policy change in your particular county, then this will be a helpful episode for you. And if you already have a county where you're getting discovery in your particular DWI cases, this is going to help you kind of push the limit a little bit, or get a little bit more discovery, or get it faster. That's what this is concentrating on, is how do we effectuate change in our local county. So going back to last episode, the first kind of way that I said it's easy to get discovery, or the first way to get discovery in district court, is through an open file policy with the DA's office. And so as I said, we're going to expound on some of the 10 ways that I went over last episode on how to get discovery. Number one way that I went through was getting voluntary or open file discovery. Now, just because a DA's office says that they have an open file discovery policy does not mean that you are then necessarily just immediately getting discovery on every DWI case. Sometimes open file discovery means we will give you whatever we have on the case, which in some counties may be nothing. So just because the DA says we have an open file discovery policy, everything that we have related to the case in terms of notes and body camera, we'll share with you. You look in the file and there is a copy of the breath test ticket, and that's the entire file. And you say, well, what about the officer's report, body camera, dash camera? And the DA says, well, we don't have any of that, so here's what we're sharing with you. That's not a very helpful open file discovery policy. So again, what we're talking about today is basically, how do you get your DA's office locally to adopt an open file discovery policy, number one. And number two, if you already are operating in a office that has an open file discovery policy, how do you get that discovery more easily, faster, more discovery? How do you kind of, again, get the discovery in a more timely process? Now, two quick opening points. First of all, a message to any DAs that are listening, because I have had some DAs, assistant DAs, that have told me that they've listened to the podcast. This is not meant to be some sort of undermined episode, and my episodes are not meant to kind of like stick it to the state in terms of trying to find some underhanded way of achieving a victory. The goal in the criminal justice process should be to get a conviction where a conviction is warranted. That's the goal of a prosecutor. The prosecutor stands in a position where they're not bound to be fighting for the interest of this particular person or that particular person, generally speaking. And in many DWI cases, who is the victim of the crime? Well, literally listed on the officer's report is society, right? So this is a war. The prosecutors are bringing a war on behalf of the people of the great state of North Carolina, and it is an important job. And what I would say is that if you are approaching the position, approaching prosecution with a eye towards doing justice, you're going to command more respect in the courtroom. You're going to command more respect among the bar. And in all honesty, you're likely going to be regarded as somebody that is really battling in the right way, and somebody that's not afraid to turn over whatever there exists on the case to the defense. So it's a real credibility point, in my opinion, when prosecutors bring information to the defense that sometimes isn't required and sometimes is, but it still requires an act of justice, an act of courage to bring that forward. So I would encourage any prosecutors that are listening to the podcast to continue listening, not only in the future, but in terms of today's episode, to help us effectuate this positive change for everybody. Second kind of overall point before I dive into kind of the specifics of effectuating this policy changes at the local level, is that when we think of a courtroom warrior, when we think of somebody that is battling on behalf of their client, when we think of like the ultimate trial attorney, we generally think of that attorney in Law and Order, in some glorified lawyer movie that is delivering the closing argument, that is aggressively cross-examining a witness on the stand. And that is all well and good. That is a something that we should think of. If I asked everybody for a second to close their eyes and to think of the trial warrior in your local jurisdiction, immediately one or two men or women would come to mind in your mind's eye of that's the trial warrior. That is the person that is going to stick it to the state, that is going to push their client's case as far as it can go, that is going to defend the Constitution, that is going to defend their client's rights, come hell or high water. This is the lawyer that is absolutely going to battle on behalf of their client's position. And again, it's good to think of those trial warriors. But what we don't often think of when we think of a trial warrior is the person that is behind the scenes making policy changes, behind the scenes getting a copy of the officer's report, behind the scenes getting a copy of the body or dash cam video. And in all honesty, that is where cases are lost and won. It's awesome getting up and fighting in front of a judge or a jury on behalf of your client. It is a great privilege to be able to practice law in real time in the courtroom, but cases are won and lost through the discovery process. So if we want to be trial warriors, then the best way that we can do that is to make sure that we are not leaving any stone unturned on behalf of our clients. And that really begins by making sure that we have looked at every piece of discovery that exists on the case, thought through them, watch any video that might exist. That's where the real lawyering is done, is in that behind the scenes process. So this is a really important objective for all of us at our local levels to pursue. So in terms of having a voluntary or open file discovery policy, trying to move towards that, if you're in a county where there is not an open file discovery policy at the district court level on misdemeanor cases, or furthering the open file discovery policy that exists, we're going to talk about the conversations that need to be had with the DA's office, how to have those conversations, who to talk to, when to have the conversation, what is the convincing the state of the value of an open file discovery policy, addressing the roadblocks that exist, making sure you're clear about what you ask for, and setting deadlines. So those are some of the things that we're going to be talking about on today's episode. So to begin, when you go speak to a DA, you want to go with as much authority as possible. If you're trying to effectuate a broad, wide-scale change in your local jurisdiction, then you want to go with as much authority as possible. And in all honesty, it's probably easier to effectuate a wide-scale change when it comes to discovery at the district court level than it is trying to individually get pieces of discovery on your own. Now, we're going to talk in future episodes about how you individually as a lawyer can try to get discovery back on behalf of your client. And some of these things are going to be very nuanced and really kind of require a case-by-case application of when are these types of discovery worth requesting on behalf of an individual client. But in terms of the biggest changes, a lot of times the easiest way to make that happen is to go at it from more of a 1,000-foot view, as opposed to being in the weeds requesting discovery on behalf of this or that particular client. So if you're trying to go with a mindset towards achieving broad discovery change, broad policy change, then you want to go with as much authority as possible. Maybe go and speak to your local public defender and see if you can get them on board to go and have a conversation with the DA's office with you about this particular issue. If you have a local defense bar, go with the authority of the local defense bar. We talked about back on episode 46 with Megan Burke what the value of a local defense bar has been in Buncombe County in particular, but more generally speaking, what the value of a local defense bar is. If you do not have a local defense bar, go back and take a listen to episode 46, because in all honesty, it might be better to start by getting everybody on the defense end on board together, as opposed to, again, individually going and having a conversation with the DA's office. So you want to go with as much authority as possible. If you can go in to the person that you're trying to effectuate change through and say, listen, the local county defense bar has met. We had a discussion about discovery at our last defense bar meeting. Here are some of the top priorities that we've identified. Here are some of the changes that we are hoping to work with the DA's office on to help streamline cases, to help streamline the process for this, to not waste officers' time and court time. You basically can go with the authority of other people, then you're going to be in much better shape than if you're asking, again, as a individual to kind of make a change just for you. That's going to be a lot harder for the DA's office to get on board with, and also for the actual kind of instruments of sending discovery to actually make a difference. So when you're trying to effectuate broad policy change, go with as much authority as you possibly can. Now, who do you talk to? Who is it that you are talking to? Well, oftentimes we I think maybe get stuck at the gatekeeper level in terms of policy decisions. This looks very different county to county. In some counties, smaller counties, there is one assistant DA that basically runs traffic court and handles all of the superior court matters, is handling everything under the sun. In other counties, there might be 25 different ADAs that are running around in district court. So who do you talk to? Well, this is a real skill in terms of identifying who is going to be important. Maybe it is a specific assistant DA that is clearly in charge of the policies that are ongoing in district court. Maybe it is a specific senior administrative assistant that is, calling a lot of the shots about, is making all the, calls to victims, is the one requesting discovery from officers, is following up with people to make sure that subpoenas are getting served. There may be an admin team member that is very much responsible for the task of getting discovery. And so you want to include that admin team member in the conversation, because otherwise you get a assistant DA on board with, yeah, hey, I'd love to get you guys discovery on the case, but then they're not the ones responsible for requesting it from the officer. So, that they can just say, hey, this all sounds awesome to me, but I don't really do any of this. So you have to figure out who is kind of critical in terms of these discovery decisions. It might be, the local police departments that are needing to get on board with open file discovery. And so really you're kind of then, asking the DA's office to be a mouthpiece to the local police departments in terms of coordinating a systematic way of getting discovery back on district court files, particularly as we're talking about today, DWI discovery. So identify who is important in terms of the decision-making that's going to go on the policy discovery end. And what I would say is a best way to kind of identify this is by asking the DA, hey, when you are trying to get, an officer's report or video on a case, who are you asking for that? Who is that request going to? Are you sending that request directly to the officers that are involved? Are there other people that are doing the same thing, other ADAs? Is there a specific administrative assistant that is in charge of requesting discovery? Try to find the person that this process, even in its like kind of maybe broken current form, is operating through. Because again, if you can kind of get that person on board with the policy change, you're going to be in a much better position to have that broad scale policy change actually get implemented correctly. Do not miss the kind of key first position of getting the right person involved. It's important, I think, to when you're having these conversations, not to make anybody feel left out. That this is an opportunity for leadership of the admin assistant at the DA's office, of one of the assistant DAs. If you go in and say, hey, I noticed that you are, running a really good courtroom in here, that things seem to be moving really fluidly. I think that there's some ways that we could work together to kind of fast track getting discovery back on cases, shorten the timeline. Again, we're going to talk about some of these kind of like reasons why getting discovery back benefits the state as much as the defense. But if you're basically kind of showing that, this person that you're speaking to, the assistant DA, the administrative assistant, is an important part of this overall process, you're asking them to kind of be included, and you're showing the person that deference, that again makes it clear, hey, I've got an important role in this overall process. So don't just step over, the proverbial gatekeeper. You actually may be able to reach the true decision maker easier if you've got a person that may be somewhat lower on the totem pole, or generally is not in charge of making these policies, that can step up and say, hey, look, I've identified a way that we can really fast track DWI cases and probably get a lot of cases handled in half the time that it is taking now for us to make this work. So don't merely step over a gatekeeper because you recognize that somebody else is important. Try to get as many people on board that are going to be in charge of the decision making, to be able to really think through the logistics of improving the discovery process. So identify who to talk to. Next, where do you have the conversation? Where do you have a conversation about discovery? Well, it's not in the midst of a 100 margin morning in a district court right at the beginning of calendar call. If you want to effectuate policy change, this is not to say like you're asking for discovery on this specific defendant that's on today's calendar. If you're trying to effectuate broad policy change, you need to do that in an environment where the assistant DA, the administrative assistant, whoever it is that you're talking to, has time to think. So you want to schedule that time. You want to say, hey, I have some ideas about discovery in district court, some ways that we could potentially fast track that and how that benefits the state. Do you have time, in the next week to sit down with me for an hour to go over some of my thoughts on that? Hey, John, hey, Jane, I just wanted to sit down with you for a little bit. I've got some thoughts on how we could improve the district court discovery process. You seem like you're really running a great, efficient courtroom. And so I feel like you'd really be able to get on board with this and kind of help to make our county operate better. This is going to save everybody's time. Schedule that time. Don't do it when the DA is in a rush. Don't do it when they are, trying to deal with 100 defendants in the gallery, 20 victims, 15 officers, 25 defense lawyers. I mean, that's not the time to have this kind of a conversation. So you want to schedule that and then operate around the person's schedule that you're talking to. When they may be free, may not be the best time for you. Operate around their schedule. Hey, this is an important conversation that I think is really going to benefit everybody. You let me know when you're available and I will do my best to operate around your schedule. So get it scheduled. Okay. Get this scheduled. Now, when you go in, be clear before you go into this meeting about what you are asking for. Be clear about what you are asking for. And here is my word of advice. If you are operating in a county where there is not open file discovery currently, then you want to keep the request small and simple. Use that KISS principle. Keep it simple, stupid, to start the discovery policy change. To go from discovery not being given in district court at all to having some discovery is a monumental movement. So don't go in saying, hey, we would like the officer's written report, narrative. We would like the dash cam video, body camera video. Go in with a simple request. It would be awesome if we could get the officer's DWIR, if there's one that exists. Is there a way that we could make that happen so that we can go over that with our clients, explain the findings of the officers, the observations about the field sobriety test? Is there a way that we could get the just the driving while impaired report? If you are trying to get more discovery in your county than currently exists, identify the biggest item of discovery that is missing. Maybe it's body camera for one particular police agency. Hey, we're getting great discovery from you guys. It seems like we're, you guys are really giving us the narrative, the DWIR, we're getting body camera, dash camera, but this particular police agency never seems to get us the body camera. Is there somebody at that agency that y'all can talk to streamline that? Is there a way that is there some way that we can help in terms of asking for discovery directly from that agency? Keep the request simple. Don't make it complicated. The more hoops there are to jump through in terms of, well, how are we going to get, the DWIR? How are we going to upload body camera, dash camera? How are we going to share that with each defense lawyer? Don't make it overly complicated. Start with one request. To go from no discovery to a little discovery is a big movement. So start small and then come back 6 months later and ask for the next thing, but start small. Keep it simple. Stupid is the operating principle by which we want to go in. So be very clear about what you are asking for. Discovery can mean a lot of different things. It could mean, the officer's report. It could mean the lab report. It could mean a officer's curriculum vitae. It could mean, other types of video, the intox room video. I mean, it could mean a lot of different things. So identify specifically what you are asking to be shared. And if, again, you are in a county where there is no open file policy, I think that the easiest place to start is the DWIR, because that's just so easy for the state to get a copy of. I mean, it really is like just, tell officers to scan it, upload it, send it to the DA assistant that's in charge of discovery. And that's it. Like that's the end. I mean, it's just really something that could be streamlined quickly with a little bit of organization and asking. So, identify what you're asking for. Keep it simple. Don't ask for everything all at once. Next, you have to tell the state what the value is in sharing discovery. If the state's position, and again, I think that there is some level to where this, doesn't make sense in light of Brady. But if the state's position is, well, it's discovery, district court, we're here in North Carolina, district court discovery is not required, right? Like that's the thing that I've heard in counties where there is no open file policy. Then you have to convince the DA's office as to why they should voluntarily disclose that evidence, why they should voluntarily share evidence that they're not mandated to share. So what are some of the values to the state of sharing discovery? Well, transparency and fairness is item number one. It just doesn't seem fair from an outside perspective for the state to not share the information that it has on a case with the defendant. There's a reason why on Superior Court matters that discovery is mandated very clearly by statute, regardless of whether that discovery is helpful to the defendant or not. And it's in the interest of justice. It's in the interest of transparency. It's in the interest of fairness. Hey, we believe that your client is guilty of a charge. Okay, can you tell me why? No, we can't tell you why. Well, then, what are we supposed to do? Plead guilty. That seems kind of, absurd, right? We want an explanation. We think that your client is guilty of driving while impaired. Why? Well, because right here on the DWIR form, it shows that your client, showed clues on all three SFSTs, was falling over, was belligerent, blew a .24 on the PBT. Obviously, again, that can't come into evidence, but all of these different things that are on the DWIR that then you can go have a meaningful conversation with the client about. The earlier you get that back, the better off you are going to be. So, transparency. Number two reason that there's value to the state, because it will result likely in more pleas faster. Right? If you are trying to kind of get discovery in this basically very backwards way of, okay, well, the case is now set on the officer's court date. On the officer's court date, I'll go try to talk to the trooper that was involved, basically have a conversation, with them where they basically read to me without me being able to look at their DWIR and tell me why this happened. Then I go have a conversation with my client in the hallway. Normally, you can't just like take that and have it result immediately in a plea. And again, from the client's perspective, it's like, why can't we just look at the report? Like, I mean, what, you're going into some back room with the trooper that charged me and having this conversation, and that, they're telling you these things, but I'm not able to see any of this with my own eyes. Like I'm trusting you to have like kind of correctly interpreted. It feels very, very bureaucratic in terms of how it doesn't feel transparent at all from the client's perspective. When you go in very early after the case and say, hey, look, I went on your first court date. I got a copy of the driving while impaired report. Let's set up a time to go over that. I've got a copy of the video back. Let's set up a time to review that. The amount of pleas that has caused, because from the client's perspective, they don't know what the officer is looking for. The defendant charged doesn't know what the officer is looking for. I can't tell you, and well, I mean, all of us that are practicing DWI lawyers know this, how many clients call in and say, I aced the field sobriety tests. I aced them. I was, perfectly able to communicate with the officer. There was no reason why the officer should have pulled me over. Whatever the kind of perspective of the client was, there was no reason for me to be stopped, no reason for me to be arrested, no reason for me to ask to blow into the portable breath test. And then you watch the video and you're like, well, video says otherwise. You read the officer's report and it's like, well, here's what the officer is going to say should this case go to trial. So it's going to result, if you give this information early to the defendant, in more pleas occurring at a faster clip. What does that mean for the state? Well, they have to issue less officer subpoenas. I had a case in Buncombe County, it's probably been 5+ years back, where we had requested discovery court date after court date. And this was from a local township police department that just did not really have a good system for sharing information with the DA's office. I had requested the discovery from the DA's office, who had an open file policy at the time, repeatedly. They had repeatedly, and they were able to show me proof of a request that they had sent to the local police agency that was not getting them information back. This thing went on and on and on. And finally, about a year and 4 months after the charge, we come in for trial. I'm just like, hey, we got to, the judge is getting tired of the case being on time after time at this point. The officer, there's 3 officers from the local police agency. They are able to give me a copy of their report. They're able to say, we've got body camera on this case. I say to the judge, hey, I need time to review this. The judge basically is like, well, I'm not going to continue it. I need you to go, watch this basically right now. I go into the room with my client, watch the discovery, and it's terrible for my client. Is it, it basically is an unattackable case. And ultimately we ended up pleading to the charge based on what we had seen, but it was a humongous waste of everybody's time. It was a humongous waste to have it on the court docket, 6 or 7 times that it didn't need to be. It was a humongous waste of time of these 3 officers that are from a very small agency. It's probably like half their police department was in the courtroom at that particular time. Because why? Because they hadn't given us the discovery beforehand. So, it would involve less officer subpoenas having to get issued by the DA's office. It would involve in less wasted time in court. And on the DA's side of things, it would result in less last-second preparation, right? The DA a lot of times is having to, go into court, go into trial blind. There might be some places or certain DAs that are a little bit more kind of on the prep end, getting ready for upcoming trials. But, for the most part, there's a lot of trial prep that's happening moments before a case is called for trial. So what does that mean? If you have less cases that are going to trial simply because there's not been a sharing of discovery, a meaningful opportunity to talk with a client and say, hey, here's the risks that we run if the case goes to trial. Here's the evidence that the state has against us. If you can't sit down and tell the defendant, tell your client, here's what the state's evidence is against us. There's almost, unless there's going to be some sort of real sentencing problem, there's almost no reason to have the case be pled on the DWI. I mean, it's kind of like, well, we're being asked to plead to this thing blind. How can I convince my client to do that? I mean, and how can I in good conscience convince my client to do that? It doesn't make sense. So it involves less last second preparation on the state's end. So those are some of the benefits to the state: transparency and fairness, more pleas at a faster clip, less officer subpoenas, less wasted time in court, less last second preparation on behalf of the DA. What are the roadblocks that the state is thinking through? Well, I would say that the number one roadblock is the burden of collecting this evidence. If you're asking the state to produce, you driving while impaired reports, to share with you officer videos, they have to coordinate collecting that from local agencies. So there is a time burden that exists, and maybe in smaller counties in particular, this is a hard thing to kind of justify time-wise. We've already got enough on our plate, and now you're asking us, whether it's me, the assistant DA, my administrative assistant, whoever it might be, you're asking us now to go spend our precious time, pulling the teeth of local law enforcement agencies to get them to share the information with us. So, that's a real roadblock. And again, what you need to be able to do is be the salesman to the police agencies through the DA's office. You can share, look, if you want your officers to have to spend less time in court, to be subpoenaed less to court on trials, just tell them that when they share this information with us, that allows for attorneys to have conversations with their client about entering a plea. Ultimately, this benefits the individual officers and means that they have to come to court less. Ask them to figure out how to streamline this with one agency. And again, this is why I think starting small is important, because if an agency, if the DA's office, let's say, is getting all of the reports and dash cam from Highway Patrol within 45 days, they can now tell every other agency that they have a conversation with, here's how the Highway Patrol is doing it. Hey, local police department, we're getting the drive while impaired report and the state highway patrol narrative, full packet of discovery, the dash camera within a month and a half. To tell me where the roadblocks are on your end. That means that you guys can't do that same thing. When you have one agency that is setting the precedent, it becomes easier then for the DA's office to move that to other agencies. So again, keeping it simple might mean not only just requesting the driving while impaired report only, but also keeping the request simple in terms of who you're requesting that from. So the burden of evidence can be a item. Now, what I will tell you, this is from personal experience. I have looked at a lot of counties, discovery processes. I probably handled a DWI it's probably been like 25 plus counties that I've handled a DWI case in. And what I can tell you from having practiced in all of these various spots across the state is that when there is an office that has a, discovery packet that is ready to go on the first court date, it massively increases the speed at which a DWI can be handled. Just massively increases that. It also really, again, emphasizes the trust level of the local DA's office. I mean, I would tell you that the DA's offices that are able to share that discovery just appear from an outside perspective to have their stuff in order. When you're negotiating with the DA, and you say, well, hey, can you tell me a little bit about what's going on in this case? They pull the file out, they open the report. Here's what was going on with the case. You want a copy of this? I mean, it's a much better bargaining position for the DA in the courtroom to be in, to say, hey, how hard is it to have a conversation from the DA side of things to be going in blind about pleas as well? Right? Whether it's trying to kind of determine if there's gross aggravating factors, if the defendant is saying, hey, well, we might be trying this case on PC, and the DA can say, well, but, here's what it says. It says your client, was staggering around on the side of the road, threw up in the bushes, failed to walk and turn, failed to one leg stand. What are we talking about in terms of doing a PC hearing? There is so much more authority on the DA side that it really just puts a different bargaining position for the DA's office. So you're putting in, I would say, maybe more time on the front end to get that discovery, especially to set up the logistics of how you obtain that discovery and to get the processes and the systems in place to get the discovery from the local law enforcement agencies. But you're banking a ton of time over the long haul of the case, not having to go and do that individually, piecemeal. Once you set up that flow of incoming discovery, it becomes very easy to request that on a specific case or to have it show up automatically if that's how you have it worked out with local law enforcement agencies, which I know that some counties do. So, there's this roadblock, which is, okay, we're going to get overburdened as a staff. And again, now actually getting this discovery up front and having a system in place is going to save you time over the long haul. Second burden would be, well, this is going to result in more cases going to trial, right? If we give you guys the discovery, there's going to be more cases that go to trial. And that's just absolutely not the case. If you're going to trial on a case where you don't know if there's a good issue or not, the only way to figure that out is by taking it to trial. The only way to kind of see what the state's evidence is to take it to trial. Now, if the defense gets a DWIR back or body camera back that shows weak PC or shows reasonable suspicion, is not present, or that there was a problem with how the breath test was conducted, whatever it might be. If you get that evidence back and it shows that the defense has a good case to take to trial, well, that was a case that was going to trial anyways. It's just that they got the discovery up front. It's not going to save cases from going to trial. Doesn't make any sense that would cause that person to not go to trial if they didn't know what the evidence was. But if a case is going to trial simply because the defendant doesn't know what the evidence against them is, and the only way to figure that out is to push a case to trial, then a case has now gone to trial that may not have necessarily needed to go that route. Again, this should result in more pleas, not less, because if the only way to get discovery is to go through the trial process, then you're likely going to have more trials in that type of a system. Final roadblock would be that this, by giving discovery to the defendant, would result in more not guilties. Now, I'm going to be, I would say, generous in terms of answering this objection. And I don't think that this would be the objection in many DA's minds or kind of from a county perspective, the kind of process. But if the reason for not turning discovery over is because there might be more not guilty verdicts or more cases dismissed, then that's a real problem. That's a real problem in terms of kind of in my humble opinion, very poor prosecutorial mindset. The goal of the state is to get justice, not to get not guilties, or not to get guilty verdicts, is to get justice and bring truth and fairness into the courtroom. So I'm going to just kind of pretty quickly skip over that. If that's the objection that you meet when you go in, you may be in big trouble, because to me that's a objection that is really not easily overcome. But I also don't think that would be the mindset of most prosecutors or DA's offices in general. So once you have figured out who to talk to, you've identified a time and place for the meeting, you're very specific in what you're asking for, you communicate to the state what the value is, and you have identified and addressed any roadblocks to a discovery policy change. Now what you need to do with the DA's office before you end the meeting is set a deadline. You got to have a deadline. And this isn't like a ultimatum in terms of you better do this by X date or else, right? But you have to have some sort of a deadline. How long do you think it would be appropriate for me to follow up on this issue with you? That's the best way to start, right? Like, do you think that 30 days would give you guys enough time to get this off the ground? How can I help you in this endeavor? Is there anybody else that I need to talk to? What is going to prevent this policy from going into effect by X date? You have to have a deadline. And I would say that regardless of the level of confidence that you have in this policy getting off the ground, you should have a follow-up meeting scheduled with the person that you're meeting with to request the policy change, just to see how this change is going on. Now, to close, this is going to take a lot of time. This is no small endeavor. This is no small movement, but kind of like we just talked about in terms of the burden of time on the DA's office getting discovery. Yes, maybe it's short-term burden, but it's long-term freedom, because now they can get cases handled more quickly. More cases are pleading, which means less time in trial, which definitely takes longer to occur than a plea. It's less time for them to subpoena witnesses, to prepare a case for trial. There's a ton of time freedom that comes down the road because they did the upfront work. The same is true for every defense attorney across the state that is trying to effectuate discovery policy changes that lead to more sharing of information and more easy access to discovery. It's going to feel like a huge burden up front, a huge time commitment up front, but it's going to lead to more freedom down the road, because the faster that you get discovery, the more streamlined the discovery process is for you to then be able to have that with your client. Again, the faster that cases can resolve on the defense end of things. If you don't figure out until 8 months down the road what the officer's report and video look like, and that's when you're having that conversation with the client, you potentially wasted a lot of time if you could have had that same discovery back within 6 weeks, within 2 months, and had a discovery conversation with your client earlier in the process. So these are going to be time-consuming conversations. This is going to be a commitment on your end to really move the needle when it comes to more open file discovery policies, but it is going to be worth it. We're going to continue the conversation in terms of sharing discovery here in future episodes, and I look forward to speaking with you again next time.